Good afternoon, my friends and followers. I'm your lawyer, Patrick McGeehan. I am your best friend at your worst time. This is a follow-up I did to a video last week where I got a risk protection order vacated in a case here in Daytona Beach. Florida Risk Protection Order Part 2, if you will. I've been getting a lot of questions from emails, comments, and other lawyers about how and why I did this, and I just thought I'd explain it a little bit further. I had a client that was arrested here in Daytona Beach for an aggravated battery. The City of Daytona Beach Police Department filed a risk protection order. They were granted a temporary ex parte risk protection order and had him served where he lived down in Broward County. So if you don't know what a Florida risk protection order is, sometimes they're called red flag laws, sometimes they're called extreme risk protection orders. Whatever they're called in your particular state, about 20 something states have them. In Florida, after the shooting at Marjorie Stoneman Douglas High School, the Florida legislature came up with a Florida risk protection order, which allows a court to deprive you of your Second Amendment right if they find you to be a danger to yourself or others. And it's used in a lot in this part of the state. It's used a lot in Polk County. Some parts of the state they rarely use it. It's not too common that people are represented in these particular cases. Usually, it's so soon and they're so shocked they go in and try to represent themselves. But to give you a rundown of the process, only a police officer or law enforcement agency can file these in Florida. In other states, anybody can file them, relatives or whatever. But in Florida, only law enforcement or law enforcement agencies can file these petitions for risk protection orders. Once they file a petition, they send it to a judge. They have a little hearing on the telephone that you know nothing about. You don't even know this is in the works or in the process. The officer or law enforcement agency, in this case, the city attorney, has a little hearing with the judge, and the judge decides whether or not to enter what's called a temporary ex parte risk protection order, which temporarily and one-sidedly, that's what ex parte means, uh, infringes upon your Second Amendment rights and prohibits you from buying or possessing guns or ammunition. So they enter this order. I've never seen a case where they didn't enter a temporary. They always enter the temporary, and then they have you served. And it meets the due process requirements because they have you served. They give you notice of what's been filed against you, and they set a hearing for you. And like I said, most people show up because they're uninformed. They show up by themselves, unrepresented, and end up getting a risk protection order entered against them. A lot of people are like, I don't own guns, so what? Big deal. I'll go, instead of going through this whole process, I will enter into this and agree to it. The problem with that is when you agree to it, the court makes a finding that you're a danger to yourself or others, and that can be used against you because it will show up in a background check. And if you're going through a divorce or you're having child custody issues, that can be brought in to either terminate or modify your time sharing with your children. It can certainly cause a problem with employment. It can cause a problem with housing because it shows up on background checks. So even if you're not a gun owner, they can still file these against you. If you get mad and you make any type of threat, especially if that threat involves some type of shooting, you make any type of threat, they can file one of these against you. You don't have to be a gun owner. They file these against all kinds of people. They file it against elementary school kids. They file it against a lot of kids that make threats to harm other students or shoot up schools or whatever. So this law came into effect after the Marjorie Stoneman Douglas shooting. It was challenged on a constitutional basis. It's such a new law. There's very little appellate law that's involved in this case, in this statute. And it was already challenged on at the appellate level on due process issues in a case called Davis versus Gilchrist County Sheriff's Office. And the sheriff's office prevailed because when they did that analysis for due process, they did a weighing of the interest, saying basically the state has an interest in preventing, shootings and incidents like that, violence and that kind of stuff. That weighed against the infringement upon the rights, because the risk protection order is only valid for 12 months and then it has to be reevaluated and it can be terminated, which they rarely do. Before that 12-month period comes up, it can be dissolved. Rarely do they do that. And since it's temporary, it was a proper infringement. But since that time, a Supreme Court case came out called NYSERPA versus Bruin, which changed the landscape of Second Amendment law in this country. And the Florida Risk Protection Statute had not been challenged under that new case law that came out. So I challenged it in this particular case, and I have the order hot off the press here for you to take a look at. It's been redacted to take the defendant, the respondent's name out in the case number. But it's a Volusia County case, and it's an order vacating the granting of a temporary risk protection order and canceling the final hearing and withdrawing the petition. The government, when they file this, whether it's a law enforcement agency, the city attorney, or whatever, on behalf of the officers, when they file this, if it's a represented person like they did in this case, they will call up to see if they will voluntarily enter into it. So my client did not want to voluntarily enter into this agreement. I agreed with that assessment. And we told the city attorney, no, we're going to fight this. So he was like, okay. And the government wins like 99.9% of these. They win an overwhelming amount of them, and they have little fear of going forward based on that. So we filed our notices of appearance in the case and requested discovery and got the final hearing extended so we could do discovery and depositions. And I also filed a motion to find the statute unconstitutional. Well, when I filed that motion for the find the statute unconstitutional, I get a call from the city attorney that says, "Hey, we've changed our mind. We're not going to go forward with this. We're going to let it work out in the criminal court." So that's what they did. They voluntarily agreed to withdraw their petition and request that the temporary get canceled. And why is this important, or why is this a big deal? Because they never do that. I've never seen that happen. I've never even heard of that happening here in Florida. And, you know, the city attorney can make whatever argument they want to make about why they did it. And, you know, that's up to them, and we may never know. But it is my opinion or best guess that they did it because they didn't want to be in a test case and be the first agency to possibly lose on constitutional grounds on this particular statute by this motion. The motion I wrote was, I spent probably about 50 hours just researching it and writing the motion. It's a quite extensive motion, and it really just laid it out step by step. And I think the city attorney did the right thing by withdrawing it. On the other side of that, since they withdrew it, the case no longer exists, and we don't get to challenge it again. So I'm looking for other cases to challenge it under. This particular case had a very good set of facts, which benefited my client. Even the facts that the police officer stated in the report, a lot of them were to his benefit and supportive of used in support of the motion that I drafted in this particular case. Anyway, so that takes care of the process and what happened in this particular case. I've been getting a lot of questions, even from other lawyers, about how I did this. They want to see copies of my motion and all that stuff. I've been getting a lot of inquiries about people who've had risk protection orders entered against them. And I'm reviewing a bunch of cases. A bunch of new cases came in where risk protection orders are being sought against particular clients, and I'm reviewing those for similar facts or facts that could lead to a similar result as in this case. Anyway, I wanted to address one comment in particular, which I partially did, but let me read you the comment here. I put it up on the screen so you could see it. On my workbench 7000 last week commented that the issue he has with the red flag laws, and these are sometimes called red flag laws, it depends what state you're in, extreme risk protection orders, or whatever, is that when they have the hearing, the judge decides if you can own or purchase or possess firearms and ammunition. You're not there and you do not have representation at the hearing. The judge only hears one side of the argument. So let me stop right there. That's the ex parte part of it. That's the little phone hearing the city attorney had with the judge, where the city attorney says, "Hey, this is what I think," and the judge goes, "Okay, we'll enter the ex parte." You're not there. You don't have an attorney there. You don't even know this hearing is going on. And he asked, whatever happened to the due process clause of the 14th Amendment? Whatever happened to the 6th Amendment where you have a right to face your accuser? Why is all this done in secret? I just subscribed to your channel. Thank you. I appreciate you subscribing to my channel very much, since I only have a few subscribers, like 3,500, I think it is, but I need to grow it even more. So I'm trying to get more serious and bring you more information, more useful information for you. Okay, we already discussed the issue about the due process clause. Um, Previously, it was challenged on due process grounds, and the statute was found to be constitutional. Whenever you have a temporary deprivation, the more temporary it is, the more likely they're going to find it constitutional. For due process in these cases, very similar to domestic violence injunctions, where due process is satisfied by notice and an opportunity to be heard. You get notice that you're served, there's a hearing, you get to be heard at the hearing, and the judge makes a decision. And like I said, 99.9% of the time, the government wins these particular cases. So they are not scared to go against you at all in these particular cases because they just win an overwhelming amount of it. The first hearing that he's talking about, the ex parte hearing, it's not done in secret. It's actually an open court hearing. If you knew about it, you could attend, but you never know about it because they're not notifying you before they have this hearing. But if you happen to be searching the docket and it pops up and you see it before they have this actual hearing, um, technically you could attend. But what happens is by statute, they have to have this hearing in a very short time after the filing of the petition. So chances are you're never going to know this hearing took place to begin with. So that's the deal with the due process clause. On the motion where I challenged it, I didn't challenge it under the due process theory. I challenged it under the new law laid down by NYSERPA versus Bruin from the Supreme Court, where infringement upon your rights has to have a historical analog. It doesn't have to be exactly like it was back at the founding, but it has to have a historical analog dating back to the founding to be successful in the infringement upon the right, and some other case law on that I'll get into further in other videos. So that wraps it up. I hope if you asked any questions about the risk protection orders, or if you get any questions in the future about risk protection orders, you'll let me know. I'm looking through cases and I'm looking for cases which with similar fact patterns as my client has to see if I can find another case where I can get this to an appellate level and maybe get this, it's a long haul, but maybe get this overturned in the state of Florida. As again, thanks for watching. I love bringing you this information. I appreciate the time you take to watch these videos. My purpose here is strictly to inform you about nuances in the law, that a lot of stuff that I see that people don't understand. If I see a lot of stuff goes on in court where people don't understand what's going on, and I try to remember those or jot them down so I can make an informative video for you. But if you like this type of content, please consider liking and subscribing. And as always, be careful out there. Until next time, see you later.